Now, constitutional checks on power. This is something that was asked of me in one of my classes recently. They wanted to see how these checks and balances work. This isn't all of them, but this is a good summary of them and how they work. First of all, when Congress passes a law, it goes from the House to the Senate. They both agree on the law. Then it goes to the President for his signature. But the President has some veto power here, doesn't he? He can override that law if he feels it's bad. The President can veto the law. Now, does Congress have any recourse with that? Of course. We know that Congress can override the veto with a 2/3 vote in the House and the Senate. Doesn't happen very often, but they certainly can do so. Now, here's an interesting question that I find very rarely is understood, and that is, does the President have any recourse now? Yes, he does. By virtue of the fact that powers were delegated to 3 separate branches. The power to legislate was given to Congress. The power to execute the law was given to the executive, the President. And the power to judge was the judiciary, the Supreme Court and the lower courts. That was an intentional separation of powers so that he who makes the law is not the same person as he who is implementing the law. And that can be a check against bad law. And so the President has the power to refuse to enforce a law. Can you think of any examples of that, good or bad, of the President not enforcing laws that are on the books? Probably one of the most prevalent that I can think of is our immigration laws. As much as I disagree with him not enforcing those laws, that is his position to do so. Whether he's abusing the power or not, he can do so. And that's exactly where we are today. Now, does Congress have any recourse? Well, of course, yes, they do. There's always the power to impeach, something they use very rarely. In the case of President Clinton, for example, the impeachment process, it first begins in the House of Representatives, where the House pulls together evidence and goes through impeachment hearings, and in the case of President Clinton, he was impeached. They felt that there was enough evidence that there was a case, and that's really all they do with the impeachment. That then goes over to the Senate, and in the Senate, they then try that impeachment. And in his case, they did not convict him of what he was impeached for in the House. So it's very rarely used, but that is their final trump over this whole power struggle here. In a war battle between checks and balances, I guess you could say, between the different branches, Congress wins. On the other side, it's Congress against the Supreme Court. When Congress passes a law, we know that the courts often will judge the law as well as the fact, is the way it's put in the Constitution. The fact meaning whether or not, in fact, I am guilty of violating a law. Did he or did he not violate the law? But they can also judge the law. Now, this is a common misconception. The concept of judicial supremacy is what it's generally called. The idea that the Constitution means whatever the Supreme Court says it means, nothing more, nothing less, even if what they say it means is totally disconnected with what the Constitution says. That's where we are today. Whatever the Supreme Court says is constitutional law, regardless of whether there's any backing for it in here. Somehow, I don't think that was what they intended. In fact, the power of supremacy that the Supreme Court has, they gave themselves. In their own court rulings, they gave themselves the power to be the final arbiter of what is and what is not constitutional. Legitimately, they simply have the power to judge the fact, whether or not you violated the law, and to judge the law, whether or not it applies in this case. If you're a 90-pound woman and there's a law against shooting people and killing people with a gun, and yet you're attacked by a 300-pound man, and having no option but to save your life but to shoot someone with a gun, you violated the law. But they could rule that, yes, in fact, you're in violation of the law, but it doesn't apply in this case. She had no choice. It was self-defense. And therefore, the law is not applicable in this case. Does that shoot down the law? There's no longer a law in the books? No. And that is the power that the Supreme Court has. Roe versus Wade, for example, should not set a precedent and create new law. It simply applied to Roe and Wade and nobody else. And the next abortion case that comes up, they might rule differently or not. Now, if they feel that there is a law that is just a bad law, they can refuse to say it applies ever. This law is never applied by the courts. At that point, Congress could review the law. and determine this law is never enforced, perhaps we need to rewrite it or repeal it or something like that. But the courts don't have the power to strike a law from the books, just to not apply it. It's up to Congress whether or not they want to remove a law. Now, if the courts do refuse to apply laws on a consistent basis, does Congress have any recourse on out-of-control judges? Actually, they have many things they can do. Of course, again, the power of impeachment. But in addition to that, and that takes a 2/3 majority, the others take simple majority in Congress. They can limit the jurisdiction of the courts. This is found in Article 3, Section 2, Clause 2. And there it says, it's speaking about the jurisdiction of the courts. First of all, it says the Supreme Court shall have appellate jurisdiction on cases that are appealed up to the Supreme Court, both as to law and fact, there's that part, with such exceptions and under such regulations as Congress shall make. Congress can make exceptions and regulations to the jurisdiction of the Supreme Court. For example, Congressman Ron Paul has introduced a bill over and over again called the Sanctity of Life Act, in which he proposes, with a simple majority of the House and Senate, we will rule that the Supreme Court has no jurisdiction on the constitutionality of abortion. That would, with a simple majority, overturn Roe versus Wade, just by Congress. Simple majority vote in the House and Senate. And it would get rid of that law that was incorrectly made by the Supreme Court. He then goes on to say, let's also make a national declaration that life, by definition, begins at conception. And that would then require the states to apply whatever their laws are that protect life to equally apply whether you're born or unborn. Very simple, but it's a way of reining in the courts. That same power could be used to rein in the courts, such as they have no jurisdiction to rule whether prayer is appropriate in schools. And they could overturn that as well. And then the last one here, they can dissolve or reorganize the lower courts. At the beginning of Article 3, it says that it establishes the Supreme Court, and then it says, and such inferior courts as Congress may from time to time establish. Such as our Ninth Circuit Court, which is one of a lot of press because their rulings tend to be overturned by the Supreme Court more often than anybody. And there's been much talk about Congress dissolving the Ninth Circuit Court. They could replace it with nothing if they chose. They could replace it with several circuits. However they wanted to do, that's up to Congress. And again, simple majority vote, they could rein in an out-of-control court. In both cases, Congress has the final trump over the other two branches. They're clearly the most powerful, like I mentioned earlier. Now, is there anyone that can override the power of Congress? Before the 17th Amendment, when our U.S. senators were directly appointed by our state legislatures, we didn't vote for our U.S. senators. Before the 17th Amendment, it was the state legislature that appointed senators. So the state legislature could rein in our U.S. senators, and always, we the people have directly elected our U.S. congressmen, our U.S. House reps. So the people had the power, and the state legislators had the power over Congress. We're more powerful than Congress. And lastly, we are more powerful than our state legislators because we elect them as well. So this entire checks and balances power struggle ends in we the people having the most power of all, which I feel goes directly to this quote from Abraham Lincoln. He says, "We the people are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow men who pervert the Constitution."